Mr. Pierre Jefferson is present in court, standing to my immediate right. Pierre Jefferson. Your Honor, we have had an opportunity to...
Your name, sir?
Pierre Jefferson.
Thank you.
This courtroom opens quietly, but don't let that fool you. What unfolds here is a masterclass in how quickly freedom can vanish inside four walls and a judge's robe. In just a few minutes, we're going to watch three very different defendants stand in front of Judge Simpson, each hoping for mercy, flexibility, or just a second chance. What they get instead is a brutal lesson in how the justice system weighs risk, history, and credibility. We begin with Mr. Jefferson, a man facing accusations so serious that the law itself allows him to be held without bond. His attorney argues innocence, financial hardship, and community ties, but the prosecution paints a far darker picture. A knife, a victim, and a defendant already on federal release. This isn't just about money. It's about whether the court believes this person is safe to walk back into the world. Then comes Mr. Salisbury, whose case spirals into a chaotic retelling of a domestic violence incident that ends with police using force on a balcony. You'll hear how one moment of defiance can transform into felony charges, and how a criminal record from decades ago can still dominate a man's present. And finally, we meet Ayanna Johnson, whose freedom hangs not on violence or weapons, but on alarm clocks, testing windows, and missed deadlines. Her case becomes a tense tug-of-war between confusion and accountability.
We have had the opportunity, Your Honor, to have the PCC, and we are set to go to exam at the next available date. If I may briefly address bond.
Discovery ready?
Yes, Your Honor, discovery is complete.
I believe so, Your Honor. There might be some videos outstanding. I will look into that today and get anything turned over as soon as possible.
People have their witnesses available March 5th.
We will try to.
Preliminary examination will be set March 5th, 9 a.m. in person. That will be before Judge Perry. Next to bond, briefly.
Yeah, as to bond, Your Honor, Mr. Jefferson is a lifetime resident of the state of Michigan. I do understand these are capital offenses he's charged with. However, the presumption of innocence must weigh in, and the bond that's currently set is tantamount to remand. He has insufficient funds to come anywhere near.
But it's 2 CFC first. He could be remanded without bond.
True statement, Your Honor. However,
I know.
However, we're asking the court to lower the bond.
Response from the people.
Your Honor, I'm going to request that bond remain as it is. The accusations in this case are incredibly serious, that the defendant was engaging in contact with the victim, who was a sex worker, and held a knife to her throat while he assaulted her. In addition, I understand he's on pretrial federal release for weapons offenses and fraud, and has bench warrants outstanding in the 15th District Court. So I believe bond is appropriate.
He was on federal release when,
Your Honor,
these allegations came up?
Your Honor, he was on federal release, and he's being...
When these allegations arose?
Yes, Your Honor. When these
motion for bond reduction denied.
This is one of those moments where the courtroom temperature drops instantly. Judge Simpson doesn't hedge. He doesn't soften it. He actually says the bond is too low. That's judicial language for, you're lucky it isn't worse. Let's unpack what just happened. The defense leaned on two pillars, the presumption of innocence and the defendant's lack of money. Both are legally valid arguments, but bond is not a reward for innocence. It's a risk calculation. The prosecution brought three devastating facts: a knife allegedly held to a victim's throat, federal pretrial release, and outstanding warrants. That combination tells the court one thing: pattern. When a judge hears, "You were already under supervision when this happened," it reframes everything. It says the system already trusted you once, and that trust was allegedly violated. Notice how Judge Simpson cuts off the back and forth. "Counsel, I don't know what you want me to do." That's not frustration. It's finality. He's signaling that no amount of reframing will change the math. In his mind, this isn't about affordability. It's about public safety.
Your Honor, if I may finish, please, briefly, if we may.
Go ahead, so I can just get to what I'm going to...
Part of his release was that he clear up his warrants. He surrendered himself voluntarily on
He was on
February
pretrial
14th.
release when these allegations came up. They're capital cases, counsel. I don't know what you want me to do. Quite frankly, I think the bond's set too low. Motion for bond reduction denied. Thank you.
Thank you for your consideration, Your Honor.
Don't get smart with me, counsel. That won't work well for you.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Salisbury. Mr. Salisbury, will you please state your name for the record?
Todd Michael Salisbury.
All right. What do we
Your
do?
Honor, may we approach? briefly.
Okay, fine.
Thank you.
That was bad. That was my bad. All right, record to reflect we had a bench conference in this case.
Thank you, Your Honor. As to the probable cause conference, we're asking for an adjournment. We are waiting on a 911 call. So I think a 2-week adjournment would be sufficient for that. And then
March
I did wish
14th, 2024, 9 a.m. Yes, as to bond.
I did wish to bond. I'm asking for a personal bond today for Mr. Salisbury. He did has a pretty serious injury as a result of these charges, and that does require some extensive medical treatment as well as surgery in the near future. He is from the area. He does have a job that he can return to, but I would ask that he be able to attend to those medical from out of custody.
Response.
We would object to any modification in bond in this case. It is a domestic violence incident. That is a misdemeanor tagging on here. This is a felony R&O. The reason for the R&O is because when law enforcement arrived on scene, the officers tried to separate the defendant and the victim so that they could interview them separately. They took the defendant out onto a balcony, and while he was outside, he began yelling back at the victim and refusing to comply when law enforcement tried to get him to stop yelling at the victim. He multiple times ignored lawful commands. At one point, they had tried to grab his arm to escort him away, and he pulled away. He crossed his arm back as if he was going to punch the officer. At that point, the officer grabbed his arm in attempts to prevent him from punching. At that point, because there was a railing and they were on a second story, the officer had tried to push the defendant away, but he did not want him to fall over the railing, so he pulled him back. But the defendant was still not compliant at that point. And then the officer tried to deliver a single knee strike to the defendant, which was ineffective in getting him to comply. So they continued to give him orders to put his hands behind his back. At that point, it did not work, so they pushed him into a wall to limit his movement and were successful in handcuffing his left hand, but he continued to not comply and swung around. And at that point, another officer administered a takedown. And at that point, only at that point, was it effective in getting the defendant to comply. He has an extensive criminal history dating back to 1996, including an 2008 conviction for unarmed robbery, a 2010 conviction for Utah, a 2010 conviction for a home invasion third, a 2011 conviction for larceny in a building. He does have a hold out of Canton for $300. At this point, I don't think it's appropriate to reduce bond at all.
Anything else, Ms. Happ?
Your Honor, I would leave it to what I previously stated. I would just acknowledge that he, as I stated, he does have a criminal history, but that most of it is not from any time in the recent past.
But his medical needs are being attended to by the Sheriff's Department, so he's getting to his appointments.
My understanding is they do have him scheduled for the follow-up, but the recommendation from his physician is that he needs surgery. I have great confidence that the Washington County Sheriff's Office will get him to his surgery if he needs it. Understood.
Motion for bond reductions denied.
This segment is a perfect example of how courtroom narratives are built, not by emotion, but by accumulation. Mr. Salisbury's attorney presents him as injured, local, employed, and in need of medical care. That's a human story, but the prosecution responds with a procedural story. Commands ignored, officers endangered, a near fall from a balcony, and a use of force sequence that escalates step by step. The key phrase here is felony R&O. That's resisting and obstructing a police officer at a felony level. And notice how the prosecutor carefully reconstructs the event. Every command ignored, every physical movement, every escalation. This isn't about one bad moment. It's about a pattern of defiance under stress. Then comes the history. 1996, armed robbery, home invasion, larceny. Judges are trained to evaluate risk over time. Even if these convictions are old, they tell a story of how someone behaves when conflict appears. The defense tries to soften that, not recent, but Judge Simpson cuts through it with calm certainty. The sheriff can handle the medical needs.
Thank you.
Is in Zoom from the MDO. They're signing in 2 people. I don't know who that is.
Is Ayanna Johnson.
Bridget Coons on behalf of Ms. Johnson, state your name for the record.
Ayanna Johnson.
Your Honor, this one also has a bond violation.
Oh, yes, it does.
Addressed first. So there is a few late tests, quite a few. I did speak to Ms. Johnson. She was under the impression that the test was supposed to be from 9 a.m. till 12 p.m. And that kind of does reflect on these missed tests, as almost all of them, or late tests, as most of them are submitted between the 9 to 12, it looks like.
Well, except for, no, I see what you're saying, but then on the 12th, she seemed to miss both. Like she missed 2 of her testing. Look on March 12th, the 6 to 9 a.m. was missed, and then the 12 to 3 was missed, and there was no retest on that one. That same thing happened on the 17th, where the 12 to 3, there was no retest.
Okay. On March 12th, I do see one was submitted at 9:34. She gets off of work at
Right,
1 p.m.
no,
Yeah.
hold on, I just want to make sure we're clear. On the 12th, there are 2 tests. If you look at the very first 2 entries, the first test, it was a 6 a.m. to 9 a.m. test. She didn't test until 9:34. Then on that same date, there's a test between 12 to 3. That one she missed entirely
I see.
and didn't retest.
Well, I have had the opportunity to clarify the time for her. We anticipate no further violations. After all this, she has never tested positive once for alcohol. So we'd be asked that she be allowed to continue on bond, and then to adjourn this to allow more tests to come through to prove that she is a good candidate going forward for resolution on this case.
Is she really going to be able to do this? Because if I do that, any more missed tests, then she's going to go.
Okay, I just need to know what times I need to know the correct time.
Well, they gave you the time.
That's what I'm saying though. So that's on, they gave on the paper, it say from 6 a.m. to 9 a.m. and then one from 12 to like 3 o'clock. And then the other one say 9 to 12 a.m.
Well, yeah.
So I
Okay.
I got my alarm clock set for 9 o'clock p.m., 1:30 p.m. and 9:30 p.m. That's not right.
So you're basically, your alarm clock is going off a half an hour into the testing schedule.
Is it?
Well, I don't know.
I think you
Okay,
need to-
look, ma'am, the tests that you're missing, Miss Coombs is right. The 6 a.m. to 9 a.m. test fundamentally is the test that you're missing.
Okay, so I'm just taking it too late.
Yes,
Okay.
but that's a miss.
So you got to reset your alarm maybe to 9 or 8 a.m.
Yeah.
Or 7.
Yeah.
Or 6.
Yep.
Somehow or another, that 6 a.m. to 9 a.m. test, you got to get in.
Okay.
You're right, you do tests, but some of these tests are an hour and a half, almost 2 hours after the end of that period.
Okay.
And so what I'm saying is, I'll give you another shot, but you need to understand something. If I have another missed test, because I should really consider all of these tests positive.
This is the moment Ayanna Johnson's case turns from administrative to existential. Missed tests don't just look like scheduling errors, they legally function as presumptive positives. That's huge. In probation and bond conditions, absence often equals violation. The court isn't tracking intention, it's tracking compliance. Judge Simpson is laying out a reality most defendants don't fully grasp. The system doesn't care why you were late. It only cares that you were. The window is the rule. Outside the window is a failure, and failure has consequences. What makes this tense is that Johnson isn't defiant. She's confused. Her alarms are set wrong. Her understanding of the schedule is flawed. But confusion doesn't suspend conditions. The judge even admits he's being generous. That's rare. Judges usually don't offer options in violation hearings. He explains the math clearly. One more miss, and he has to act. Not might. Has to. Judges don't like being boxed in, but policy boxes them anyway. He's warning her that mercy is temporary.
Okay. But if I give you that chance, if I have another missed test,
I'm gonna go to.
then I got to, I got to do what I got to do. Now, the other option is I can switch you over because of this violation. I can switch you over to a scram tether.
What is that? On my ankle?
Yes.
Why are you yelling at me?
I'm not yelling.
I'm giving you, normally I don't give options. I don't know why I feel so generous today. I know, it's like unusual.
It's on your ankle. You don't even.
Usually if I had a report like this, ma'am, I'm going to tell you, you'd be going to jail right now.
Okay.
So what would you like to do? Take the chance that I let you go and you test on time, or you want to scram tether?
Is that gonna dig into my ankle and how do that work? I don't know what that is, so I gotta ask.
They put it around your ankle, and then if there's any alcohol consumption, we're gonna know.
How long I gotta wear it?
I guess the best answer until I say you don't. I know this is hard because
I can't walk around.
I know fashion. Go girl.
Yeah, I can't walk around with
I don't know.
tether on my
What do you
ankle.
want me to say?
I'll just do the blow.
Really?
Yeah, I'll do it on time. I'm gonna change my alarm. I can't walk around with no tether.
Really?
This scram conversation is deceptively light, but it's actually a fork in the road. Scram is continuous alcohol monitoring. It removes ambiguity, no alarms, no windows, no excuses. The ankle becomes a witness that never sleeps. Johnson's hesitation isn't about technology, it's about identity. I can't walk around with no tether. That's stigma talking. A visible marker of supervision feels like punishment in public. Blowing into a device is private. A bracelet is permanent. Judge Simpson even cracks humor. Your tether didn't go with any of your outfits. It's a joke, but it's also a reality check. Compliance often conflicts with lifestyle. The court doesn't care about convenience. It cares about verification. By choosing the breath tests, Johnson is choosing responsibility over automation. She's telling the court, trust me. But trust in this system is conditional. It resets with every alarm. This is a subtle psychological test. Can she restructure her life around compliance, or will routine overwhelm intention?
If I ain't got no
you
choice,
could.
I could, but if I got a choice, I'd rather blow.
I know. Emily, your tether didn't go with any of your outfits, did it?
Like what?
I'm sorry.
I'm not wearing that.
I just. Okay, I'm sorry, Emily. Didn't mean to let that out like that. Defendant to have no further missed tests. When did you want this adjourned out to?
Can we have a month?
And I'll adjourn this. You gonna make it a month? What? Why are you looking at me like that?
I'm gonna make it.
I'm just at. Okay.
I'm gonna make it.
No, I'm gonna put it in the file. She said she gonna make it. Then when you don't, if she doesn't make it, don't be begging me to do anything different. I gave the warning.
What we've just witnessed is not one case. It's three philosophies of accountability colliding with reality. Mr. Jefferson learns that past trust magnifies present risk. Mr. Salisbury discovers that resistance, even in moments of chaos, carries lasting weight. And Ayanna Johnson confronts the brutal truth that freedom in the system is conditional on precision. Judge Simpson's courtroom is not emotional, it is architectural. Every decision is built on structure, risk assessment, history, pattern, compliance. Bond is not mercy, it's probability. Will this person return? Will this person comply? Will this person escalate? In Jefferson's case, the answer was no. In Salisbury's, the risk outweighed the need. In Johnson's, the door remained open, but only barely. One more misstep and that door closes. This is how the justice system actually works. Not in dramatic verdicts, but in incremental trust. Every appearance either strengthens or weakens your standing. And that's the real lesson here. In court, your future is shaped less by what you say and more by what you consistently do. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.